Welcome back to Breaking History, the Supreme Court Historical Society's show where we highlight modern scholarship about the Supreme Court's endlessly interesting past. I'm Ross Davies, and today I am joined by Professor Jonathan Lurie of Rutgers University. From the 1970s to the present day, Professor Lurie's writings on American legal history have covered a remarkable range, from trade regulation in the Midwest, to Reconstruction, to military justice, to presidential legislative powers, to the Supreme Court, including the courts led by Salmon P. Chase in the 19th century and William Howard Taft in the 20th. It is the last of those vast specialties, if specialties they can be called, that we will be focusing on today because the latest issue of the Journal of Supreme Court History includes Professor Lurie's review of Robert Post's new 2-volume history of the Taft Court. And that is what we are going to talk about in the next 20 minutes or so that we have together today. Professor Lurie's thoughts about Professor Post's thoughts about the Taft Court. And for starters, Professor Lurie, you have in fact written a first-rate history of the Taft Court yourself. No need to modestly protest, it is true. And so you are perhaps uniquely positioned to identify a couple of especially fine new discoveries or insights provided by Professor Post in his new book. In other words, what novelties did you most appreciate when reading Post's book?
Well, the biggest difference between my book and Post's book is that Post's book is an exhaustive, thorough, detailed 2-volume work on the Taft Court. Mine isn't. And as I said in my introduction to Post's book, it won't need to be done again. We now have a definitive history of the Taft Court. And one thing about the Taft Court, it has to be seen in the context of Taft's career prior to the court, because he had dreamt of being on the Supreme Court from his earliest days in politics. He hoped that Benjamin Harrison would appoint him to the court, but of course that didn't happen. And when, on that Christmas Eve, as I recall, Warren Harding invited the former president to visit with him, he said to Taft that, "Would you like to go on the court?" And Taft was really genuinely surprised and explained that he'd love to go on the court, but he could only be Chief Justice because there were still a number of his appointments on the court. Taft had 6 appointments to the court, as I recall. That's a large number. Indeed, he had more appointments to the court than any president in one term since Washington. And some of them were still on the court. Vandeventer was still on the court. He had been a Taft appointment. I'm trying to remember his name, but there was another justice who was still on the court. And he felt it would be inappropriate for him to serve as a peer with people he had appointed. So he explained that it could only be Chief Justice. And very fortuitously for him, the current Chief Justice died in 1921 in May. And I won't say that Taft finagled to get Harding to name him, because Harding was fully aware that he wanted to name him, but he wanted to name 2 judges at once, and that meant you needed a second vacancy. And that didn't occur until Taft was on the court. And then Harding named several justices as well. So Taft brings to the court a unique perspective. No other man has ever been president of the United States and a member of the Supreme Court, let alone Chief Justice. I'd be surprised if that ever happens again. But it has not happened since. And the presidency was, I won't say unpleasant experience for Taft, but he was not a happy president. Uh, and he loved judging. He had a wonderful saying that he said, judges are he said the world is served by outstanding judges. They make the world go round, or something to that effect. Those aren't his words, but that was his thought. And to be on the Supreme Court as Chief Justice was the apex of his accomplishments, he thought. Now, what did he bring to the court? Well, he had not practiced law in 30, 40 years. He was not a outstanding lawyer in any sense of the word, but he was a inquiring mind, and he knew something of legal theory. And he liked to talk and discuss and explore. And in his first half of the court term, remember, he was only on the court for 9 years. That's relatively short as appointments to the court go. You think of William Douglas, who was 36 years, or Field, who was 34 years. This was just 8 or 9. So in that time, his first half, he was in good health, and that's his background. Now let me say a quick word about several of his colleagues, because they're important. He served with two of the greatest judges in the court's history, Oliver Wendell Holmes and Louis Brandeis. Both were on the court when he arrived, and both were on the court when he retired in 1930 and died a few weeks later. And both brought a very different perspective to judging than Taft did. Now, it's important also to remember that Taft grows more and more conservative as he gets older. He always had a streak of conservatism in him, but it was balanced by a healthy strain of progressivism as he understood it in the early part of the 20th century. Remember, he's president from 1909 to 1913, and the era of Woodrow Wilson as president hasn't happened yet. Theodore Roosevelt is in his second term, and Roosevelt would have appointed Taft to the court. And indeed, he offered Taft an appointment twice. And each time Taft turned him down. And you might ask, well, if he wanted to be on the court so much, why did he do it? Why did he turn them down? It's a good question. Well, there's an answer for that. The first is that at the time, Roosevelt had him in the Philippines working as governor general of the Philippines, and he didn't want to leave until he had done what he set out to do. And the second, I mentioned already, he couldn't be on the court, he thought, until he became Chief Justice. And for that, you had to have a vacancy. And Teddy Roosevelt never appointed a Chief Justice. So it wasn't until Harding came along and Chief Justice White chose to die that he got the vacancy. So that's why he kept turning Roosevelt down for at least twice. So that's what he brings to the court. He brings a third thing to the court that's important. He was a superb administrator. People don't appreciate that. And that's in part because history has not treated Taft, I think, fairly, because he was wedged between two dynamic presidents. On one hand, you had Teddy Roosevelt, who brought a new meaning to the terms bully pulpit and provided a type of presidential leadership that had been rare up until then. And the second, on the other side, is Woodrow Wilson, the professor turned politician, turned governor, turned president. And Wilson, who had an ability to encapsulate in words some impressive ideas, has a reputation that far eclipses Taft. So he's sort of like the stale filling between two fresh pieces of bread, you might say. Roosevelt on the one hand and Taft on the and Woodrow Wilson on the other. And people tend to slight his accomplishments. I'll say a little bit about them. He served one term, but it was a term of no war, of major reform in tariff. It was a time when he accomplished much of what he wanted to do. And because there was no killing coal strike, which galvanized Roosevelt into action in the first year of his term, and there was no World War, which is Woodrow Wilson's legacy, again, Taft is sort of nudged aside as the man who kept the fires burning, kept the coal on, and I'm not sure that's too fair. But anyway, that gives you a little bit of an answer, my friend.
Yes, indeed, it does. And the irony of being not a a great figure in history because he was a president of peace and reform, it's almost tragic. Now, Professor Post's book is his contribution to the Oliver Wendell Holmes Devise series. And in the tradition of that series, it is in no small part a history of the internal workings of the court, the individuals who served, how they interacted with each other. And you've mentioned a few of the justices with whom Chief Justice Taft served, including a couple who were appointed by him. Were there any particular relationships on the court that Post highlighted or might have highlighted that were particularly significant or interesting? You mentioned, for example, Holmes and Brandeis. How did Taft get along with them? Or Van Devanter? How did he interact with him? Or what have you? What can we take from those relationships?
One of the accomplishments or talents of Taft is that he was able to get along with anybody. Was a very friendly, outgoing personality. As you know, he was a big man. He not only filled the role of president or chief justice, he kind of overflowed it. And he loved talking with people. He got along with Brandeis and Holmes very well. He was genuinely fond of Holmes, who was rapidly approaching 90 when he was on the court. And he didn't think much of Holmes as a constitutional scholar. He wrote to a friend that if we had followed Holmes's view of the Constitution, we wouldn't have had it. It wouldn't have survived. I'm not sure that's true, but he felt that Holmes brought a style of judging that wasn't Taft. On the other hand, he was jealous of Holmes's great gift of brevity and succinctness. To this day, you read a Holmes opinion and it sparkles. And you don't find that in Taft, unfortunately. His opinions are long, dull, boring, exhaustive, and that's again unfortunate. Brandeis, on the other hand, was probably the sharpest legal mind on the Taft Court. One of Brandeis's associates on the bench was a Harding appointment named George Sutherland. Sutherland was the one Harding wanted to name with Taft, and he had two vacancies at once, but he didn't. And as soon as the next vacancy arose, he promptly named Sutherland, didn't even ask him. As it happened, Sutherland was in Europe at the time, and Harding just appointed him. And when he came back, Harding said, by the way, you're on the Supreme Court. And Harding said, okay. And he stayed on the court until he retired in the, I think it was the late 30s or early 40s. But Sutherland said of Brandeis, he said, I despise some of his opinions, but he is the sharpest legal mind I've ever seen. And that's a good description of Brandeis. He was probably the best lawyer on the court. And generally his colleagues knew it. Now, his Taft's closest friends on the court were Sutherland and Vandeventer. He also got along very well with Pierce Butler, who was another Harding appointment. Interesting thing about Pierce Butler is that he never went to law school. He was one of the few surviving who read law, quote unquote, in a law firm and ultimately passed the bar. But be that as it may, the only one I think who didn't have much use for Brandeis was the most obnoxious member of the Supreme Court in its history, a judge named James McReynolds. McReynolds was a bigoted, anti-Semitic grouch who had no use for anything that he was not familiar with. And that was the world in 1930 or 20. And Brandeis, as a Jew, as a liberal, quote unquote, would of course have rubbed McReynolds the wrong way, but he went to extremes. McReynolds would turn his back to Brandeis when Brandeis was making a point. He would interrupt him. He was downright rude to attorneys. And he was a abrasive, obnoxious personality. And as you may have gathered, I have no use for him whatsoever. And the one issue of Post's book is that Post likes McReynolds much more than I do. I think he was one of the worst judges in the history of the court. I don't think Post would say that. And the reader can decide who's right and who's wrong. Certainly, in terms of posterity and reputation, I think McReynolds has pretty much got what he deserves.
Practical anonymity, right?
I'm sorry?
Practical anonymity. He's largely forgotten, right?
Well, he was He was not a likable man. On the other hand, there are those who say that he was especially kind to younger lawyers, and he was not. He There are some good things to McReynolds. I just had trouble finding them.
My impression, by the way, both from my own time spent with Post's book, reinforced by your commentary, is that if there is any evidence either way about McReynolds' merits or demerits, you can find it in the text or the endnotes of Post's book. Uh,
Yeah.
it's all there, right?
That's one of the problems with Post's book. And as I said at the beginning of my review, it's hard to know what he could have done otherwise except cut the notes down. And he didn't want to do that as a scholar. And I frankly don't blame him.
Yeah.
But it makes it very difficult for the reader going through these two huge volumes, which are heavy as well as dense. And as I say, it's been done now, and you don't need another scholarly approach to the Taft Court. You have it. I'm just glad I wrote my little book first.
In a review that I greatly enjoyed, your lines on exactly this point are among my favorites, so I'm just going to read them out loud right now. Quoting Professor Lurie here, gentle viewers, "Let there be no mistake in my emphasis that herein Post has written an outstanding and indeed definitive history of the Taft Court and its era. Those of us who would consider a return to this topic again might well be better advised to seek another subject." So if you want to know about the Taft Court, there's a large body of good work, but for the complete, the authoritative, the definitive, the book that you might differ with on some of his conclusions, but you can't differ with the care with which he has documented things, is Professor Post's. That last summary was mine. The first two sentences, more eloquent.
I agree with it.
Now, before we wrap up, one thing I'd like to invite you to do, which I know you're good at from reading your work, and that Professor Post's massive enterprise here calls for, is some thought about the lessons of history. Can you give us one or two thoughts about the lessons that we might take from Post's book and from the history of the Taft Court?
I'm not sure I can give you much on the lessons of the Taft Court. I can tell you something about the legacy of the Taft Court. It was a conservative legacy because Harding named conservative justices. Besides Taft, he named Sutherland, he named Butler, he named Sanford, and these were all conservative judges in terms of their outlook. Judges like Brandeis and Holmes were often found in dissent from the chief. And that is what Post is getting at when he says that in later years, after the Roosevelt War, you might say, in the 1930s, and after Roosevelt made his 7 appointments to the court and redid the Supreme Court, that changed. And Taft never saw that. The relationship between Harding and the court was not the relationship between Franklin Roosevelt and the court, especially in Roosevelt's second term. His first term, he didn't have the opportunity to name any member of the court. And that's one reason he was itching to do it when he was reelected. And ultimately, as I said, he named six or seven justices and redid the court, including Felix Frankfurter, his close friend, the Harvard professor, who was known by the Frankfurter and his happy crowd of Harvard hot dogs, as one critic mentioned it.
Well, there is obviously a lot more that Professor Lurie could tell us about Professor Post's book, about the Taft Court in general, and even about the Supreme Court in general. You can get started on all that by reading Professor Lurie's review of Post's book in the latest issue of the Journal of Supreme Court History, Volume 50, Number 1. And you can subscribe to the journal by becoming a member of the Supreme Court Historical Society at www.supremecourthistory.org. Thank you very much for joining us for this edition of Breaking History. Thank you very much, Professor Lurie, for speaking with us. We will be back again soon with another new and interesting look at the past.